Hello and welcome to Courts Today by Live Law. Here are today's top legal updates. Ranveer Allahabadia has approached the Supreme Court against multiple FIRs over obscenity allegations. Punjab and Haryana High Court has ordered action against 4,000 illegal constructions in Gurugram's DLF city. On the Pleas against recently enacted Uniform Civil Code, Uttarakhand High Court has said that affected individuals can approach the court regarding UCC actions. The Orissa High Court has observed that senior citizen is not entitled to receive maintenance from children unless inability to maintain himself is shown. While hearing the pleas for SC/ST and OBC reservation in Bengaluru Advocates Association, the Supreme Court has said that it will not permit the bar to be divided on caste or religion lines. A day after reserving orders, the Supreme Court has relisted Bangladeshi Immigrants' deportation case on the request by the Union of India. And Member of Parliament Ikra Chaudhary has approached the Supreme Court seeking strict implementation of the Places of Worship Act. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit our website at www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. YouTuber Ranveer Allahabadia, popularly known as Beer Biceps, has been in the headlines after his video from the show India's Got Latent went viral, where he could be seen making allegedly obscene remarks. Following the outrage, multiple FIRs were registered against him for the offence of obscenity. As of date, FIRs have been registered by the Maharashtra Police and Assam Police over the statements. Later, Allahabadia also issued a public apology admitting that his comments were inappropriate. Now, he has approached the Supreme Court seeking relief in respect of the multiple FIRs. His counsel, Dr. Abhinav Chandrachud, mentioned the Article 32 petition today before CJI Sanjeev Khanna. The CJI stated that a hearing date had already been assigned. When Chandrachud expressed concern about possible coercive action by the Assam Police, the CJI did not comment further, reiterating that he does not allow oral mentions. In the next update, the Punjab and Haryana High Court has ordered Haryana state authorities to take quick action against over 4,000 unauthorized constructions in Gurugram's DLF city within 2 months. The court noted that local officials in collusion with land mafias have allowed these illegal buildings to rise at an alarming rate. Justices Sureshwar Thakur and Vikas Suri stated that these unauthorized constructions are violating multiple laws, including the Haryana Building Code and zoning plans. The court warned that if such developments continue, it could lead to collapse of Gurugram's infrastructure, including water, sewage, transport and air quality systems. The court was hearing petitions from the DLF City Residents Welfare Association, who raised concerns about a 2018 action taken report on the issue. The authorities found violations in over 4,000 plots, but actions were only taken in some cases. The court also pointed out that civil courts had issued stays in many cases despite having no jurisdiction over such matters. It has now directed that the civil suits be closed and action against violators be completed within 2 months. In a temporary relief for individuals affected by implementation of the Uniform Civil Code in the state of Uttarakhand, the Uttarakhand High Court has today asked those affected by the UCC to approach the court if they face any action by the authorities under the code. The bench of Chief Justice G. Narendra and Justice Alok Mahra was hearing 3 petitions challenging the Uttarakhand Uniform Civil Code. Appearing for one of the petitioners, the senior advocate Kapil Sibal urged the High Court to give him a date to argue for a stay on the law. He argued that the law infringes upon fundamental rights guaranteed under Article 21 and 25 of the Constitution. Additionally, Sibal questioned the competence of state government to enact the UCC as he referred to entry 5 of concurrent list of the Constitution, which pertains to marriage and divorce. Informing senior advocate Sibal that the court has already issued notices to state government on 2 other pleas filed challenging the UCC, the bench subsequently scheduled the matter for 1st April to hear arguments on the stay of the law. The court further said that in the meantime, any individual affected by the law could approach the court and they would be given a hearing. Let me tell you, 2 other petitions are pending before the Uttarakhand High Court challenging the UCC. While one PIL challenges several provisions of the code, particularly those related to live-in relationships, another PIL plea contests the provisions of the code concerning marriage, divorce, and live-in relationships, arguing that they infringe upon citizens' fundamental rights. If you recall, on 27 January, the Uttarakhand High Court rolled out the Uniform Civil Code almost a year after the State Assembly passed the bill. It has become the first state in the country to implement UCC. Some key aspects of the law are mandatory registration of live-in relationships, conditions for a contract marriage, a ban on halal, iddat and polygamy, and similar inheritance rights for men and women. It applies not only to Uttarakhand but also to state residents living outside its territories. The application to scheduled tribes, however, is excluded. The Orissa High Court has held that simply being a senior citizen does not automatically entitle a person to receive maintenance from children unless shown that he or she is unable to maintain himself or herself from own earnings or out of owned property. In this particular case, a father filed a case against his son under Section 5 of Maintenance and Welfare of Parents and Senior Citizens Act of 2007, claiming that his son had ousted him from the house and was not providing financial support despite him being a 69-year-old. The father sought 5,000 rupees per month as maintenance. The Court of Sub-Collector STM Raigada cum Maintenance Tribunal, after hearing both sides, ordered the son to return the house key to his father and pay 5,000 per month as maintenance. The son appealed against this order to the collector, but the appeal was rejected and the tribunal's decision was upheld. Unhappy with this, the son filed a writ petition challenging the order before the High Court. While clarifying the position of law under Maintenance and Welfare of Parents and Senior Citizens Act, Justice Shashikant Mishra of the High Court observed that an order of maintenance can be passed only on finding that the children or the relatives, as the case may be, have neglected or refused to maintain a senior citizen being unable to maintain himself. So far as compliance of Rule 14 of the 2009 rules is concerned, the court held that impugned order did not pay heed to the methodology prescribed under the rule for determining the maximum maintenance allowance that can be directed to be paid. Thus, the High Court has allowed the writ petition of the son. The matter has been remitted back to the tribunal for fresh hearing now. Moving further, the Supreme Court today addressed pleas seeking reservation for lawyers from scheduled caste or scheduled tribes and backward communities in the Advocates Association of Bengaluru. The court made it clear that it will not allow bar members to be divided along caste lines or allow the issue to be politicized. A bench of Justices Surya Kant and N. Koteshwar Singh decided to tag the pleas with another matter scheduled for hearing on 17th February, which focuses on strengthening bar associations. During the hearing today, senior advocate Madhavi Diwan, representing the petitioners, pointed out that no one from the SC/ST community has been elected in the last 50 years to the Karnataka Bar Association. She highlighted the need for diversity in key positions and emphasized that young lawyers need role models. She also referred to affirmative actions in countries like the USA, Canada, and Australia to ensure adequate representation of the underrepresented groups. Justice Kant acknowledged that this is a sensitive issue and would require careful consideration. However, he mentioned that the court currently lacks sufficient facts and figures on the matter. While not commenting on actions in other countries, he expressed confidence that Indian lawmakers are aware of the need for proper representation. Justice Kant also indicated that during the next hearing, the court might appoint an independent commission or committee to collect data on a national level. Let me tell you, the petitions before the Supreme Court were filed after the Karnataka High Court declined to order the Advocates Association of Bengaluru to reserve 50% of its governing body positions for SC/ST and backward communities, which could also include a reservation for women. Last month, the Supreme Court had intervened by directing that treasurer position in the association elections be reserved exclusively for women. The court had also suggested that the high-powered committee and the chief returning officer consider reserving at least 30% of other positions in the governing councils for women lawyers to ensure their adequate representation. A day after reserving judgment in a case raising the issue of indefinite detention of illegal Bangladeshi immigrants in the country, the Supreme Court today re-notified the matter to enable Union of India to file an additional affidavit containing inputs from the Ministry of External Affairs. A bench of Justices J.B. Pardiwala and R. Madhavan passed the order upon a mentioning of the case by Solicitor General Tushar Mehta, who informed that some inputs from the Ministry of External Affairs need to be placed before the court. The earlier affidavit filed by the union in the matter was based on inputs from Ministry of Home Affairs. Taking into account the sensitivity of the case, the court permitted the union to file an additional affidavit. And lastly, Samajwadi Party leader and Member of Parliament Ikra Chaudhary has filed a writ petition before the Supreme Court seeking implementation of Places of Worship Act 1991. The petition argues that repeatedly filing lawsuits against mosques or dargahs and quickly ordering surveys without careful review can increase religious tensions and harm the country's unity. The petition warns that ignoring this trend could break the country's secular foundation. The plea mainly argues 2 points. Number one, as per doctrine of non-retrogression recognized in the Ram Janmabhoomi Temple case, it would be impermissible to circumvent the provisions of the 1991 Act. And second, that definition of ancient monuments under the Ancient Monuments and Archaeological Sites and Remains Act of 1958 cannot be interpreted to include any place of worship. Doing so would be a violation of fundamental rights under Articles 25, 26 and 29 of the Constitution. In the petition, Chaudhary also cited the violence in Sambal which occurred after a survey order passed by a trial court against a 16th century mosque. Reference was also made to how the ex parte interim orders were granted by trial courts for allowing a survey of the mosques or dargahs without any preliminary consideration or examination of the legal or factual nuances. The bench of CJI Sanjeev Khanna and Justice Sanjay Kumar today tagged this petition with connected petitions which challenge the constitutionality of the Places of Worship Act.